We trust, however, that that is not the Chief Justice's intention this evening, though he has carefully guarded the topic tonight. But the Chief's presence here to deliver the fifth Abraham Lecture is testament to Henry's life and work in the field of constitutional law and the esteem in which he is held by the highest court in the land. I refer all of you to the synopsis of Henry's career in the brochure that you received at the door. And I'd like to ask Henry to stand and be recognized by our audience. Have had or will have that pleasure in one of Henry's Judicial courses. These are provided by the university's lifelong learning program. Despite teaching these courses over the past 2 years, pro bono, as you lawyers like to call it, or as Henry calls it, for the psychic income, Henry has received the highest marks available on the course evaluations for his Judicial classes. Retirement for Professor Abraham has meant simply more time to research, write, and lecture around the country without the administrative annoyances of full-time teaching. And those of us who continue to work with him are happy that he is not yet ready to retire his 1930s vintage typewriter. Many people here tonight deserve thanks for bringing the Abraham Lecture to fruition. Mildred Abraham and Sue Rainey for their inspiration that these annual scholarly and, let's face it, social events would be an appropriate format to recognize Henry's contributions to the large audiences he has reached in his professional life. To Bob O'Neill, the founding director of the Thomas Jefferson Center for the Protection of Free Expression, who has provided a collegial and congenial home for the lectureship, along with his associates Josh Wheeler, Amy McClung, and their interns, without whom these evenings would just simply not materialize. All of Henry's friends, his family, colleagues, and former students who tonight have come from as far away as Texas, Oklahoma, Missouri, New York, North Dakota, North Carolina, to be with us for this special night. All of our donors, many of whom are here this evening, and 2 of our past Abraham lecturers, Tinsley Yarborough of East Carolina University and General William Souter, clerk of the Supreme Court. We will not ask him this evening to swear in any members of the Supreme Court bar. I've been to countless oral arguments at the court since our lecturer this evening was promoted to a center chair. I know that he maintains the prerogative to truncate speakers before him in mid-word. So before the red light comes on, I will turn the podium over to Bob O'Neill to introduce the Chief Justice with one last bit of housekeeping for this evening. We ask that there be no flash photography once the lecture begins. Thank you for being here this evening.
Barbara, thank you. For you especially, I don't think the red light is likely to go on. You have a dispensation. And for us at the Thomas Jefferson Center, the opportunity to share in this collaboration and the sponsorship of this series has been an extraordinary opportunity, which we treasure. We gathered this evening to honor 2 eminent, though rather different, legal scholars. Since the lecture series bears his name, we do first recognize Professor Henry Abraham. Through the generosity and esteem and foresight of former students, proteges, colleagues, friends, and family, an annual lecture has now become a central feature of the Thomas Jefferson Center's program, and one for which we are exceedingly grateful. We delight in acclaiming each year the legacy of Professor Abraham. We note that as a political scientist who understands the Supreme Court far better than most of us lawyers do, he has engaged shamelessly but quite successfully in the unauthorized practice of law for some 5 decades. Not long ago, as a reminder of his impact on the understanding of the court and its jurisprudence, the Weekly Standard referred to his book, Justices and Presidents, as the indispensable work in its field. Much the same could be said of his other writings, each of which has given us rare insight into the process by which justices are chosen and confirmed, how they shape the law, and how they in turn are shaped by that experience. So we do celebrate first the colleague and friend whose name graces this series. When we founded the series some 5 years ago, our highest hope was that Chief Justice Rehnquist might someday be the Abraham Lecturer. Now that hope was in one sense presumptuous, not because we had any doubt about the intrinsic appeal of the event, but only because the Chief Justice had already been so generous of his time and so gracious in his visits to Mr. Jefferson's university. Some years ago, for example, he launched a most influential Federalist Society gathering here. He's been here as our graduation speaker and as the recipient of the university's highest accolade, the Thomas Jefferson Foundation Award in Law. And just last year, he gave the keynote address as we marked the 175th anniversary of the law school. These and other occasions attest to his comfort at being among us and his generosity to this institution. So it seemed almost unreasonable to call upon him yet one more time. Nonetheless, we sensed that the Abraham Lecture was an invitation to which the Chief Justice would be receptive, as indeed he was, and this day and our hope have come to pass. Of the Chief Justice's many visits here, the one that I recall with special fondness was the Federalist Society meeting now some 17 years ago, during which he stayed with our family at Carr's Hill. He invited our children to reminisce about early days in Wisconsin, whence we had just moved, and which he recalled from earlier times in his own life. When, a few months later, he was nominated as Chief Justice, our children were delighted, and in fact they assumed they may have played some modest part in this happy event. One conversation that weekend was especially memorable, that with our son David, who even at the age of 12 seemed headed for a legal career. After that weekend, he harbored an unwavering hope that, above all, he might someday have a chance to clerk for the nation's highest court. Well, David's hopes did materialize, although not quite with the Chief Justice who had inspired him. He did have a wonderful experience last year clerking for Justice Ruth Bader Ginsburg. And during the year, he did come one step closer to renewing the ties with the person who planted the seed. Turned out that the Chief Justice's regular clerk tennis partner became ill on the eve of a critical match. So he very graciously invited David to step in, a role for which my son eagerly volunteered. Now, I never got to watch this dynamic duo, but all the reports suggested they were headed for Wimbledon. Then the regular clerk partner regained his health, and David was sent back to the minors. But he treasures this brief and exceptional opportunity that came to him, believing that if you can't clerk for the chief, maybe at least you can be his tennis partner. It's our great good fortune to have as our fifth Abraham Lecturer the Chief Justice of the United States, for whom this university and this law school have a singular esteem and admiration. No less an authority than our convener of the evening, Professor Barbara Perry, has recently written that, even from ideological opponents on the court, Chief Justice Rehnquist receives high praise for his effective and affable leadership. She also recalls a prophetic statement which he made several years before he assumed his current role. As long as the 220-odd million inhabitants of this country see fit to confide the judicial power of the United States to one Supreme Court, it is surely best that it be a collegiate court which no Chief Justice needs to or is capable of dominating or even harmonizing by virtue of his very limited special prerogatives as compared to those of his 8 colleagues. Having exemplified that spirit, we welcome the author of that remarkable statement as our lecturer this evening, Mr. Chief Justice.
Thank you, Bob, for that very kind introduction. It's a special pleasure to deliver the Henry Abraham Lecture this evening. Before I went to law school, I was a political science major, and at that time one of the recognized subspecialties in political science was constitutional law. I gather that hasn't always obtained since with some of the trends in political science. But political scientists have provided information and insights into the workings of the Supreme Court that complement books by lawyers on the subject. Legal academics tend to emphasize the legal doctrines, while political scientists tend to explore the workings of the system and the people who man it. Henry Abraham's recent book, Justices, Presidents, and Senators, is a splendid example of the latter type of work. As he puts it in his preface, a mini-history of the Supreme Court. This evening, I propose to give you a mini history of just one aspect of that institution, the extrajudicial activities undertaken by various Supreme Court justices. I'm currently working on a book about the disputed election of 1876, in which Rutherford Hayes was the Republican candidate and Samuel Tilden was the Democratic candidate. The election was, for all practical purposes, resolved by an electoral commission created by Congress, which included 10 members of Congress and 5 Supreme Court justices. The service on the commission by 5 members of the court was probably as important an extrajudicial activity as has ever been undertaken by the court's members. But in reading about it, my curiosity was aroused about other instances of such extrajudicial activity. To many of you here, probably the most familiar example of that kind of activity is Chief Justice Earl Warren's service on the commission that investigated the assassination of President Kennedy. But the practice of Supreme Court justices serving extrajudicial capacities began with John Jay, the first Chief Justice. In 1794, 5 years after he'd been appointed Chief Justice, George Washington asked him to serve as a special envoy to Great Britain to negotiate various disputes that had come up as a result of the Treaty of Paris, which ended the Revolutionary War. Jay was by no means desirous of this appointment, and he wrote to his wife, "No appointment ever operated more unpleasantly upon me, but the public considerations which were urged and the manner in which it was pressed strongly impressed me with a conviction that to refuse it would be to desert my duty for the sake of my ease and domestic concerns and comforts." It's interesting, though not surprising, that Jay does not mention the effect that his absence on such a mission might have on the Supreme Court. The Supreme Court got off to a very slow start in our country, and at this time the court was heard an average of only 6 cases a year. Most of the justices' time was spent riding circuit, sitting as a trial judge in different cities. Jay spent a year in England, and there's no indication that he was missed in the work of the Supreme Court. The treaty he negotiated aroused a storm of criticism when its provisions were published in the United States. But most historians have come to regard it as the best that could be had from the point of view of the United States. Upon Jay's return from England, he discovered that he had been elected governor of New York in absentia. You can imagine that happening. He resigned the Chief Justiceship to accept what he regarded as the more important office. Washington nominated Oliver Ellsworth of Connecticut to be Chief Justice after a brief interim in the office. He too would be sent on a foreign mission while holding that office by John Adams, who succeeded George Washington in 1797, Adams named Ellsworth as one of a three-man delegation to go to Paris and negotiate an end to the undeclared war between France and the United States. Like Jay, he was gone for a year, does not seem to have been greatly missed by his colleagues on the court. He fell ill in Paris in the fall of 1800 and sent his resignation to President Adams. Nearly 8 decades later, 5 Supreme Court justices would serve on the Electoral Commission created to decide the disputed presidential election of 1876. The Republican presidential candidate was Rutherford B. Hayes of Ohio. The Democratic candidate was Samuel Tilden of New York. As we all know from the disputed election of 2000, the magic number of electoral votes now is 270. Then it was 185. On the evening of Election Day, it appeared that Tilden had won. But quick thinking by some Republican functionaries put the result in doubt. Checking the returns carefully, it appeared that if Hayes carried the Pacific Coast states as expected, Tilden was assured of only 184, not 185 votes. The Republicans issued a statement declaring Hayes the winner, and then went to work in the 3 southern states where the vote was uncertain: South Carolina, Florida, and Louisiana. South Carolina appeared to be legitimately Republican, but both Florida and Louisiana were extremely iffy. On December 6th, the Hayes electors were declared winners in Florida by over 900 votes, but an alternate slate of electors was returned for Tilden. Similar duplicate slates were reported from Louisiana and South Carolina. The United States Senate at this time was controlled by the Republicans, and the House of Representatives by Democrats. Since Congress was the ultimate authority for deciding who had been elected, both parties scrambled for advantage. Finally, the plan which ultimately prevailed took shape: the appointment of an electoral commission. A Republican Senate and a Democratic House could never have agreed on a joint commission of only their members, which had the necessary uneven numbers to decide a question one way or the other. To the evenly divided members of Congress on the commission, there had to be added an uneven number of members from outside Congress. The executive branch, controlled by a Republican president, offered no hope of impartiality. So Congress turned towards the third branch, the Supreme Court. But it did so with great care. One of the first proposals was to name 2 justices appointed by Republican presidents, 2 by Democratic presidents, and the 5th to be chosen by lot. Tilden strongly objected to this. He was a rather frosty person, but on this occasion he coined one of his rare bon mots. He said, "I may lose the presidency, but I will not raffle for it." The proposal finally adopted named 2 members of the court who were Democrats, Nathan Clifford and Stephen Field, 2 members who were Republicans, Samuel Miller and William Strong. These 4 justices would choose a 5th justice, and the tacit understanding was that it would be David Davis, regarded as a genuine political independent. When Davis refused to serve, the 4 named members chose Joseph Bradley, an appointee of President Grant, who was the closest substitute for a political independent as could be had among the remaining members of the court. Field was the only one of the 5 justices who wanted this assignment, and Bradley must have wished it least of all. He was regarded, before the commission ever sat, he was regarded in the Democratic press as the casting vote among the 15 members. If he voted with the Republicans, he would be condemned as a party hack rather than an honest jurist. If he voted with the Democrats, he would doubtless be praised as an independent arbiter, but denounced by all the elements of his own party, which had placed him where he was. Bradley appears to have studied the matter carefully, though there was largely false reports of his having been lobbied even as late as the night before the final vote on the commission. He ended up voting with the Republican majority to count the returns submitted in favor of Hayes in Louisiana, Florida, and South Carolina, and to disregard 1 vote on a return submitted from Oregon. Predictably, Bradley was excoriated by the Democratic press. If the commission's report wasn't rejected by Congress, Hayes would be elected by a plurality of 1 electoral vote. The Senate, controlled by Republicans, quickly accepted it. By now, it was late into February, at a time in our constitutional history when the president was inaugurated on March 4th rather than January 20th. Democrats in the House filibustered for several days, trying to prevent the matter from coming to a vote. Meanwhile, Southern Democrats in Congress were dealing with Hayes' lieutenants, suggesting a basic compromise. If Hayes would withdraw federal troops from where they remained in the South, South Carolina and Louisiana, they would support the election of Hayes as president. Thus came about what is referred to as the Compromise of 1877. It was not until the early morning of March 2nd, 2 days before the inauguration, that the House finally voted and Hayes was declared elected. Respected historians have criticized the members of the Supreme Court, and in particular Bradley, for participating in such an obviously political task as deciding the winner of a presidential contest. But what was the alternative, so far as the nation was concerned? As I have noted, Congress itself could never hope to agree on a winner, split as it was between a Republican Senate and a Democratic House. Deep and bitter feelings were aroused in various parts of the country by the dispute, and there were threats of armed marches on Washington. If the participation of the justices was the only realistic route to a peaceable solution, I think they should be commended rather than criticized for this service. They may have lowered the prestige of the court, but they may have also saved the nation from an armed conflict. 20 years later, Chief Justice Melville W. Fuller would be asked to take on a different extrajudicial assignment. After the American victory in the Spanish-American War in August 1898, President William McKinley sent Fuller the following telegram at his summer home in Sorrento, Maine. It would give me great pleasure if you would permit me to consider you for membership on the Peace Commission. Wire answer, William McKinley. Fuller first wired and then wrote McKinley of his reasons for declining. He wrote, "My dear Mr. President, my duty to the country lies in the discharge of my duty to the court over which I preside. And the labors of the court are, as you know, arduous, and many matters of detail necessarily devolve upon the Chief Justice. Nothing but some imperative exigency ought to be allowed to interfere in any way with the conduct of the business that we are appointed to perform. And I am quite sure that the Chief Justice should not take on any additional burdens." Fuller's reasons, it may be noted, were quite different from those advanced by Jay a century earlier. His concern was entirely for the work of the court, which he felt would suffer if his time were spent elsewhere. The role of the Chief Justice at the end of the 19th century was much more demanding than was the role a century earlier. During the 1940s, several extrajudicial assignments arose from World War II. On November 26, 1941, a Japanese task force consisting of 6 aircraft carriers carrying over 400 planes, 2 battleships, 2 heavy cruisers, and 11 destroyers started from its staging area in the Kuriil Islands for its destination, the U.S. Naval Base at Pearl Harbor in Hawaii. Just before 8 o'clock in the morning on December 7th, the Japanese planes bombed and torpedoed U.S. planes and battleships located there. Earlier, the top Army and Navy officials in Washington sent messages to General Walter Short, who was the Army commander in Hawaii, and Admiral Husband E. Kimmel, the Navy commander there. These messages related the negotiations between the United States and Japan were going nowhere, and the Japanese military attacks against the Philippines, Thailand, or the Kra Peninsula. How many of you know where the Kra Peninsula is? I didn't either, so I guess it's down in Southeast Asia. They were expected because of the movements of Japanese troops and naval forces. December 7th, 1941, Pearl Harbor Day, is a day on which almost everyone of my generation remembers exactly what they were where they were when they heard the news. I was at my girlfriend's house on a pleasant sunny day, a rarity for Wisconsin in December. The next day, all of our high school was herded into the auditorium, where we sat and listened to President Franklin Roosevelt's speech, declaring that December 7th was a date that will live in infamy, and asking Congress for a declaration of war against Japan. More than 2,000 American troops and civilians were killed in the raid on Pearl Harbor, 140 planes destroyed on the ground, 2 battleships sunk, and 4 others damaged. The response of the American public in the immediate aftermath of the attack on Pearl Harbor was outrage against Japan, mixed with dismay at the lack of preparedness of the United States forces at Pearl Harbor and in the Philippines. Senator Robert Taft of Ohio, a leader of the isolationist wing of the Republican Party, called for a congressional investigation. Roosevelt was alarmed by the prospect of such an investigation. Release of the cable traffic would alert the Japanese to the fact that the United States had broken the Japanese code, and any open-ended investigation could provide fodder for his political opponents in the 1942 elections. So wishing to head off a congressional investigation, he created a presidentially appointed commission consisting of 5 persons, headed by Associate Justice Owen Roberts of the Supreme Court. The remaining members were senior military officers. Their charge was to ascertain and report the facts relating to the attack made by Japanese armed forces upon the territory of Hawaii. The commission went to work immediately, meeting in Washington and Hawaii. In all, the commission examined nearly 150 witnesses and received numerous documents. In late January of '42, it submitted a 21-page report to the President, which was released in full to the public. The report is surprisingly readable for a government document. The commission found that Admiral Kimmel and General Short had been repeatedly warned of the possibility of surprise Japanese attack, but had failed to work together to prepare an adequate plan of defense. The failure of Kimmel and Short to confer with one another about joint defense plans in the light of these warnings was found to be a dereliction of duty. Numerous critics of the report of the Roberts Commission have sought not so much to vindicate Kimmel and Short, but to implicate the Washington High Command from the President on down. The more extreme of these critics seek to show that FDR not only provoked the attack on Pearl Harbor, but actually welcomed it and indeed perhaps advanced knowledge of it. A more reasonable school of critics faults the military command in Washington for having itself failed in the face of an intercepted Japanese cable instructing Japanese emissaries in Washington to break diplomatic relations and instructing its embassy to burn all documents, to immediately warn the commanders in Pearl Harbor of the sharply increased likelihood of war, not in some time in the near future or somewhere else, but now and at Pearl Harbor. The Roberts Commission, holding as it did 4 high-ranking military officers and its membership of 5, deliberating within weeks after Pearl Harbor, would criticize the military command in Washington was unlikely. But the very summary nature of the clean bill of health given to the Washington brass by the report does not seem to have been the subject of any careful investigation by the Commission. Justice Roberts did not sit during the Supreme Court's argument session in January 1942. Harlan F. Stone, who had become Chief Justice 6 months earlier, expressed his irritation at Roberts' absence and at Justice James F. Burns spending time at the White House consulting on wartime economic plans. He wrote his son, "I am struggling along with the work of the court as best I can, with 1.5 men away. Roberts has returned from Hawaii, but I think he's still busy preparing his report. I'm hoping that we shall get him back on the job soon." It was to be a bad year for Stone. In June, he would read in the press of Associate Justice Frank Murphy's receiving a commission as lieutenant colonel in the Army, and he would soon receive complaints from members of Congress as to the legality of Murphy's holding 2 federal positions. A month later, he would confront the issues of extrajudicial duties directly. President Roosevelt asked him to conduct an inquiry into all things of the problem of rubber production for the war effort. The need for such an inquiry was prompted by a politically charged dispute within the administration. Stone replied somewhat effusively to the President 3 days later, "My dear Mr. President, personal and patriotic considerations alike afford powerful incentives for my wish to comply with your request that I assist you in arriving at some solution of the pending rubber problem. But most anxious, not to say painful, reflection has led me to the conclusion that I cannot rightly yield to my desire to render you for you a service which as a private citizen I should not only feel bound to do, but one which I should undertake with zeal and enthusiasm." And then Stone goes on to give some very good reasons why this sort of thing shouldn't be done by justices. He said, "A judge, and especially the Chief Justice, cannot engage in political debate or make public defense of his acts. When his action is judicial, he may always rely on the support of the defined record upon which his action is based, and the opinion in which he and his associates unite as stating the grounds of decision. But when he participates in the action of the executive or legislative departments of government, he's without those supports. He exposes himself to attack and indeed invites it, which because of his peculiar situation inevitably impairs his value as a judge and the appropriate influence of his office," which I think is a very good summary of why justices of the Supreme Court should be very, very cautious about undertaking this sort of activity. Less than 3 years later, the issue of Supreme Court justices taking in extrajudicial duties presented itself in as sharp a focus as can be imagined. FDR died at Warm Springs, Georgia in April of 1945. He was succeeded by his Vice President Harry S. Truman. The Allies in Europe were sweeping to victory. VE Day was less than a month away. In late April, Truman asked Associate Justice Robert H. Jackson of the Supreme Court to take on the job of Chief U.S. Prosecutor before an international tribunal to try high German officials accused of war crimes. Within days, Jackson wrote to the President accepting the position, and by an executive order dated May 2nd, Truman appointed him Chief Prosecutor. Jackson took on an enormous responsibility, not just as an advocate before the tribunal, but also as de facto ambassador and administrator. There had never been such a tribunal before. The United States would prosecute and judge, along with its wartime allies, Great Britain, Russia, and France. Agreement as to which country would do what and when had to be negotiated. A sizable and highly competent staff had to be assembled on short notice to depart for war-torn Europe for an indefinite period of time. Jackson made his first of several trips to Europe in late May to discuss preliminary matters. This was before the age of jet propulsion, and travel was by propeller plane. These planes could not cross the Atlantic without refueling. Thus, a flight from Washington or New York to Paris, like Jackson's, would stop at first at Stephenville, Newfoundland, and then at Santa Maria in the Azores before the final leg to its destination. Agreements were duly negotiated among the Allies over the summer. Nuremberg, Germany, was designated as the place for the trials to be held. These trials began in late November of 1945, and Jackson was the first to make an opening statement to the tribunal. He spoke for an entire day and won high praise from the American reporters covering the events. Several months later, he undertook the principal cross-examination of Hermann Goering, the highest-ranking German official on trial. Press reviews of this effort were mixed. After all the evidence was in late July, Jackson also made the first of the closing speeches for the prosecution. In August, the tribunal recessed to consider the cases against the defendants. Its judgment was handed down a month later. Of the 22 defendants, 12 were sentenced to hang, 3 to life imprisonment, 4 to terms ranging from 10 to 20 years, and 3 were acquitted. Jackson understandably regarded his participation in the Nuremberg trials as the crowning achievement of his career. Criticism of the trials focused on 2 issues. The first was whether a justice of the Supreme Court should participate as a prosecutor in such a trial. The second was whether or not this sort of trial, not only the prosecutors but also the judges coming from the victors, would in fact be a form of kangaroo court. But this criticism softened as the court amassed evidence of the evil intentions and deeds of many of the defendants, and also because 3 of the defendants were acquitted. Some of Jackson's own colleagues joined in this criticism. Justice William O. Douglas, between Jackson and whom no love was lost, opined in memoirs published many years later. Jackson was gone a whole year, and in his absence we sat as an 8-man court. I thought at the time he accepted the job that it was a gross violation of separation of powers to put a justice in charge of an executive function. I thought, and I think Stone and Black agreed, that if Bob did take it, he should resign. Moreover, some of us, particularly Stone, Black, Murphy, and I, thought that the Nuremberg trials were unconstitutional by American standards. Whatever the merit of these objections, the Nuremberg trials were surely superior to the summary court-martial proceedings favored by some members of the administration. In private, Stone was vituperative, writing to a longtime friend, he said, "Jackson is away conducting his high-grade lynching party in Nuremberg. I don't mind what he does to the Nazis, but I hate to see the pretense that he is running a court and proceeding according to common law. This is a little too sanctimonious fraud to meet my old-fashioned ideas." It's difficult not to sympathize with either Jackson or Stone's views. Jackson, speaking to the New York State Bar Association in 1947, said that his Nuremberg role was the supremely interesting and important work of my life, and an experience which would be unique in the life of any lawyer. One of Stone's complaints was that he first learned of Jackson's acceptance of the role of prosecutor when it was announced by President Truman. One would think that Jackson would have at least consulted Stone before accepting the job, not that Stone had any authority to forbid his taking it, but that advance notice would have made it more palatable to Stone, even though he still disagreed. In the presidential election of 1952, Republican candidate Dwight D. Eisenhower defeated Adlai Stevenson, the Democratic candidate, ending 20 years of drought for his party. The next year, Fred M. Vinson, who succeeded Harlan Stone as Chief Justice, died, and Eisenhower appointed Earl Warren of California to succeed him. In 1960, Democratic presidential candidate John F. Kennedy narrowly defeated Republican candidate Richard Nixon. Kennedy was the first Roman Catholic and the second youngest person to occupy the nation's highest office. He and his wife brought a sense of youth and elan to Washington. The nation was stunned when on November 22, 1963, he was assassinated while riding in a motorcade in Dallas. Lee Harvey Oswald was arrested the same day, charged with the crime. The nation's grief turned to amazement when Oswald, being televised in the custody of the Dallas police, was shot and killed by a local bar owner named Jack Ruby. Rumors of all sorts began to fly. A week after the assassination, Chief Justice Warren was contacted by the Deputy Attorney General, Nicholas Katzenbach, and the Solicitor General, Archibald Cox, to inquire if he would serve as chairman of a bipartisan commission that the new president, Lyndon B. Johnson, would create to investigate the assassination. Warren tells of his initial response in his memoir. "I told him I thought the president was wise in having such a commission, but that I was not available for service on it. Because of past experiences of that kind in the history of the court, we had discussed the propriety of taking on extrajudicial appointments. And although we had never voted on it, I was sure that every member of the court was of the opinion that such appointments were not in its best interest. I told Katzenbach and Cox that I had more than once expressed myself to that effect for several reasons. First, it is not in the spirit of constitutional separation of powers to have a member of the Supreme Court served on a presidential commission. Second, it would distract the justice from the work of the court, which had a heavy docket. And third, it was impossible to foresee what litigation such a commission might spawn, with resulting disqualification of the justice from sitting in such cases. But that's not the end of the story. Later the same day, Warren was summoned to the White House to have his arm twisted by LBJ. The president was successful. He said to the Chief Justice, "You were a soldier in World War I, but there was nothing you could do in uniform comparable to what you can do now for your country in this hour of trouble." Warren goes on to say, "He then told me how serious were the rumors floating around the world. The gravity of the situation was such that it might lead us into war," he said, "and if so, it might be a nuclear war." I then said, "Mr. President, if the situation is that serious, my personal views do not count. I will do it." The Warren Commission included a bipartisan group of well-known current or former public officials. The following September, the Commission produced on a 900-page summary of its findings known as the Warren Report. The Commission concluded that Oswald had acted alone in killing the president and that Ruby acted alone in killing Oswald. Although the Warren Report was supported by 26 volumes of evidence and testimony, from almost the moment it was issued, it came under wide criticism from a variety of sources. Hundreds of books and articles have attempted to prove that the Warren Commission got it wrong and that President Kennedy's assassination was the result of a conspiracy. The alleged participants in the conspiracy range from the CIA and the FBI to anti-Castro Cuban groups to the mafia. The Warren Commission concluded that President Kennedy was struck by 2 bullets, both fired from above and behind the president. The Commission's conclusion that there was only one gunman and that there were only 2 bullets that struck the president and Texas Governor John Connally, who was injured, involved what has been dubbed as the magic bullet theory. The Commission found that the first bullet that struck President Kennedy entered his upper back, exited through his neck, then struck Governor Connally, who was sitting in front of the president, entered just below Connally's right armpit, exited his right chest, struck and shattered his right wrist, and ended up in his left thigh. So that's what they mean by the magic bullet. The existence of the Zapruder Film, taken by amateur photographer Abraham Zapruder, reinforced skepticism in the Warren Commission's conclusion. The film shows the president's head having been thrown backwards as if a bullet had struck him in the front of the head. Amid the mounting criticism of the Warren Report, Chief Justice Warren refused to respond or defend the report, simply telling his staff that the report spoke for itself. In 1967, according to a Gallup poll, 60% of the Americans doubted that Oswald was the lone gunman in Dallas. If we step back to review the examples of Supreme Court justices performing extrajudicial duties, they were obviously different as to the time at which they occurred, the nature of the assignment, and the effect of the assignment had on the work of the court. It would be unthinkable now for a Chief Justice to leave not only the court but the United States for an entire year to undertake a diplomatic mission in a foreign country, as both Jay and Ellsworth did. But the court was a totally different institution then than it was over even a century later. And in a brand new nation of only 3 or 4 million people, there was much less choice available to the president than there would be at later times. Passing over the justices who served on the Electoral Commission of 1877 for a moment, Chief Justice Fuller was surely right in declining appointment to the Peace Commission. Indeed, there were cases which would come before the court involving the construction of a treaty drafted by the Peace Commission, which might have required Fuller to disqualify himself. Owen Roberts' service on the Pearl Harbor Commission required that he miss one of the 7 monthly argument sessions which take place during the annual term of the court. The commission served an important national purpose, to examine as soon as possible whether the loss of life, ships, and planes might have been at least partially preventable. The work of the commission could not have been postponed to the summer recess of the court and still accomplished its desired purpose. The report was of great interest to the American people. though it did generate controversy in later years. Stone was obviously correct in declining Roosevelt's request to referee a politically charged dispute about how best to produce synthetic rubber. Jackson's service as chief U.S. counsel at Nuremberg was the most harmful in its effect on the court of any judicial task undertaken in modern times. He missed an entire annual term with the court. His stature as a jurist undoubtedly contributed to the success of the Nuremberg trials. But over and above that, this role was right up his alley, the use of the spoken and written word, in a way that it would not have been for his colleagues or most other judges. There was also an element present here and not in the other cases described. It was an advocate's dream. Earl Warren, for example, accepted the chairmanship of the Warren Commission only after extraordinary importuning from President Johnson. There was surely no reason to believe that he wanted the job. Jackson very much wanted the job he was offered. The temptation to which he succumbed was far greater than in the other cases. He accepted with alacrity, thereby recognizing the possibilities of the tendered position, but also showing little regard for the effect his acceptance would have on his colleagues and on the court itself. Turning back now to the justices who served on the Electoral Commission of 1877. Should they have accepted this assignment? Even before the first meeting of the commission, each one of them could surely see that the commission's work would be the subject of violent and prolonged criticism from the party against whom it ruled. Members of the court, if not the court itself, would participate in a decision that had enormous political consequences. They would be deciding not just who was at fault at Pearl Harbor or who assassinated John F. Kennedy. They would be deciding who would be the next president of the United States. But the consequences of refusal would be equally momentous. Until Congress passed the law creating the Electoral Commission, realistic threats of violence, of armed partisans marching on Washington, were heard from several quarters. It was evident that Congress, divided as it was, could not resolve the dispute by itself. But because public opinion gradually came to prefer a negotiated settlement, Congress managed to enact a measure which was grudgingly accepted by most of the partisans on each side. As I said, the law expressly named 4 justices. If they refused, the law contained no authorization for selection of any alternates. The commission would be a dead letter, and the country would be thrown back to some form of either violence or political Russian roulette. Critics, including Earl Warren, had expressed the view that the justices serving on the Electoral Commission demeaned the court. But here one must be reminded of Lincoln's comment when he was accused of acting contrary to the Constitution. He said, "Shall I save the Constitution and lose the nation?" 4 of the 5 justices, according to Garfield, would rather have this cup passed from them. But the consequences of their refusal would have been grave if not entirely foreseeable. They may have tarnished the reputation of the court, but they may have also saved the nation from, if not widespread violence, a situation fraught with combustible uncertainty. I believe that in accepting membership on the commission, they did the right thing. Thank you.